a lot of my inventors, they want everything right now, and they want to, throw in the kitchen sink, and they want the patent, and they want the trademark, and they want the copyright, and they want all of these things, which is fine. One of the most common misconceptions from my clients is that you're limited to a patent or a trademark or a copyright, and that's not even the case at all. You can have a patent, and I use a dog washing machine as an example. You can have a patent on the technology, a trademark on your business name, and a copyright on your book, all about your dog washing machine. So the first inquiry that any entrepreneur or inventor or business owner would want to start with was, which area of intellectual property fits best for your business and for your goals? And presumably, your goals are to make money. That's why we all do this. Is we want to make the next latest and greatest thing, and sometimes that protection lies in patent, and other times it lies in trademark or copyright. And to give you an example, for companies like Microsoft, their patents are probably a bigger part of their portfolio. But if you look at Coca-Cola, their strongest protection is their trade secret and their trademark. And for Lady Gaga, it's her copyright. And so it's really involved in inquiry of talking to a practitioner and working through which one is best for you, and just keep an open mind. We have a tendency to think that we're married to a patent and then just give up if the patent's not an option. But there really could be other options for you out there. And so the best advice I could give would be to keep an open mind and say, okay, well maybe a patent isn't in my future, or maybe it's prohibitively expensive or whatever, but let's see what else I can do with this concept that I have beyond a patent.
I haven't spoken about this in a while, but I can tell you a story when I first started that I was kind of scoping out how much my intellectual property protection would cost me really going for a patent. And one attorney said $2,500, another one said $5,000. I'm just giving an example at this point. I don't remember exactly, but as an inventor, you have to go a little bit deeper, and you have to ask what it is that you're getting. And then, am I getting a provisional patent for $2,500? Am I getting a utility patent for $5,000? I need to kind of understand. And provisional patents, for example, somebody could charge $600 and somebody else could charge $3,000. So the question,
Sure.
I think, Beth, and correct me if I'm wrong, or maybe you have some input towards this on how to help inventors gauge getting quotes from attorneys. How much of the, if you're getting a provisional patent, how much of the utility patent are you adding in to this provisional patent once the 1 year period comes due and we're going to convert it into a utility? There's some that'll just take what you wrote and kind of just file it, and others will actually pretty much write 50, 60, 70% of the patent, and then when it comes time that they can just convert it and add the claims. Is that what's your take on that?
Sure. And that's an individual practitioner's choice. When I was still writing utilities, I had a tendency to charge more for a provisional if it was merited, and do that very, very, very completely. So by the time the utility rolled around, it would literally just be touching up the drawings, writing the claims, and making it just as good as possible. So I would charge less for the utility. That's just an individual preference. It's a stylized thing. I don't think there's really a right way or a wrong way to do it. But what's important for our inventors is to, number one, be involved in that process and talk to your practitioner. Talk to your patent drafter and say, okay, what are we doing? Why are we filing a provisional application if my invention is complete and ready to go? Why don't we just move straight to a utility? What is the purpose of filing a provisional? And I think the most important thing is to ask that practitioner how narrow that broad claim is going to be, because that could really determine whether or not you really want to move forward with a patent. Sometimes, the state of the art is very crowded, and your invention may be, really, really old as the hills, except for this one unique piece, which really isn't that monetarily valuable to you. So if you're going to spend thousands and thousands and thousands of dollars on a patent, make sure it's worth it to you, as opposed to spending that money on, say, okay, let's manufacture, let's sell, or let's create a business using this, because if I have a broad claim that's 56 lines long, what is the purpose of me having this patent? It's so narrow.
Right.
And those are questions that you could ask your practitioner, your patent practitioner, or just an intellectual property attorney in general, saying, okay, well, if we don't have a patent option, what else can I do? I really like my idea here. I really like this concept of having this business, and just kind of go from there, and just be open to being able to kind of rethink how you're going to move forward with the concept that you have.
Sure. Beth, what do you think about an inventor that comes to you and says, I've gone to every big box store and I haven't seen this idea out there. I'm ready to get started, Beth. Sign me up. I want a patent right now. What do you tell them? Is that the right thing for them to do?
Well, every single entrepreneur that comes into my office says there's never been anything like this, and I've looked everywhere.
The golden line.
And that's great, because it's good to show that you're doing your diligence, and the inventor is paying attention to what's going on. But the problem is that just because something isn't seen in a box store doesn't mean it's not patented, and that's where our novelty search comes in. It's a little bit different than going into somewhere and seeing something similar. It's completely a different realm on making sure, number one, that it's worth it for this inventor to move forward with a patent. And of course, a novelty search is not a legal requirement. I strongly encourage them. They're not required to do so, but it's really good for me as a practitioner. It's a good way to kind of give me a roadmap on where I think prosecution's going to go. And, if I can look at my inventor and say, look, I think you're going to get a 102 rejection on this. This has already been invented somewhere, and you're going to spend a ton of money paying me to argue with the patent office to try and get you a very narrow claim. You may want to reconsider. So I like the excitement, and I like the gung-ho, and I love the eagerness and can-do attitude that my inventors have. But part of my responsibility to them is to make sure to keep them grounded and keep them on earth and saying, okay, let's make sure that this is worth it for you, worth it in terms of what you get in the bargain and how much you're going to spend, and if it's really something that's feasible.
We definitely appreciate this information. I know there's inventors that are twiddling their thumbs saying, what do? I have this idea. I want to speak to an attorney. I'm nervous to speak to an attorney. I don't know if I'm ready to spend money. Maybe you could just give us a couple really quick tips on what you think we should do before we approach an attorney with our idea.
Well, I think when you talk to attorneys, I know that there's the persona that we sit behind the mahogany desk in the high rise and we leer at you over our glasses. And
I saw that picture of you, Beth.
What's that?
I saw that picture of you, Beth. You have a very nice desk.
But, one thing I always tell people, I get cold calls all the time. And, say, look, make sure that the attorney that you're hiring is someone that you're comfortable with. There's no requirement that you have to hire the first person that you talk to. Are they comfortable answering your questions? Do you feel comfortable asking them questions? And, it couldn't hurt to just do an internet search and see if there's somebody that'll offer a free 15-minute consult, or just say, and a lot of attorneys will do this, and I do this for people who aren't quite sure what they want or what they are doing or where they go, is that I offer my hourly consults. You can pay me for an hour of my time, bring your questions, bring your files, sit down, let's see what your options are before you commit to spending thousands and thousands and thousands of dollars and not knowing what you're doing. Or if you like to, go to a self-help website, I call them Doc in the Box, or do it yourself, or file your own patent. It's crucial that you know what you're doing before you do that.
Sure. What about
so
searches?
I would say, go ahead.
I'm sorry, Beth.
Sure.
What about search? When you said that inventors are bringing you this file, is it searches? What do we need to be prepared with? Do we need to tell you that we went to every big box store? Do we need to go on USPTO.gov, which is the United States Patent and Trademark Office website? I know you know that, Beth. But
right.
USPTO.gov website, and do a basic search What makes
Sure.
it easier for both of us when we approach you?
And it really depends on the attorney. For myself, I am of the opinion that I would rather have too much information than not enough. And so I tell my consults when they're coming in, go ahead and bring the kitchen sink and bury me, because that's what you have me for. And I can give better advice with the more information I have. But if, to the extent that you're capable, yeah, go ahead. Look on the PTO website, or even just do a Google search or a Bing search or whatever search engine you have, and see what's out there. And in terms of doing that, the best way to kind of teach yourself how to do that is think about the one thing about your invention that is unique, and what problem does it solve that none of the other inventions do. And that's kind of where you can find that kernel of novelty, hopefully. So start looking for that. Say, okay, you know what, all of the other dog washing machines have a drain that's positioned on the side, and mine's going to be over here, and that accomplishes this improvement, and it's better, so let's look for something similar to that. And so that's how you can kind of start to feel out where you are and what the state of the art is, and if it's worth moving forward with a patent for your dog washing machine, or if you might want to start thinking about talking to a trademark attorney and a graphic designer and say, I'm going to have a mobile dog washing business using my machine, or I'm going to write a book on how to make a great dog washing machine, and those types of things. So, don't be afraid to try to, find out yourself, and then just call an attorney for kind of a sanity check.
Okay. What about budget? I know you get this often, and people ask me how much it's going to cost me for patents, how much is it going to cost for a trademark and copyright. Maybe you can just give us, it doesn't necessarily have to be your hourly expenses on top and so forth, but how do you answer that question, Beth, when somebody asks you that?
It's actually very simple. Trademarks and copyrights are notoriously cheaper to obtain than patents. Patents are, I think people focus on patents because they're the most expensive and most difficult rights to obtain. To put it into perspective, the patent fees just went up, and they're $500, $600 for a small entity. Trademark filing fees are $275 to $325 per class of goods. Mm-hmm. Copyright registrations is $35 pop.
Okay.
That's it.
Now,
and so they're much cheaper.
Yep. Are these something that you recommend that inventors, entrepreneurs, business owners, companies, corporations do themselves?
You can. For some of my larger clients who are filing lots and lots of copyrights and lots of trademarks, I make it a point to sit down with them for a day. They pay me for a day, and I teach them how to do it, because the easy part is filing the application. Where it gets difficult is where you have to argue with the trademark office, where you have to argue with the copyright office. Well, usually I'm seeing more of those, but not as often. Or where you have to argue with the patent office and those types of things. And where, actually just filing, I would like, please, trademark office, may I have this particular trademark? Filling out the paperwork online and hitting submit is easy. Where the need for a lawyer comes in is, can you have that mark? Are you going to get sued for infringement for using that mark? And what do you do if the trademark office says, no way, you can't have this mark, and you disagree? That's where the lawyer comes in.
Got it. So it's not really, it could be an argument or it could be a compromise.
Yeah, and I'm a lawyer. I love to argue. And so that's why I go back to that consult thing. I don't encourage doing it yourself because it puts the impetus on the inventor or the entrepreneur to almost put on a lawyer hat and kind of understand the nuances of trademark law. But if you do, the only thing I can say is please find a lawyer who does consult and just make sure that you have a sanity check, you're doing it right, you know what to expect. Or if you get in hot water, you move forward, you do it yourself anyway, and then you get this very intimidating looking letter with the USPTO's logo on it, and you can't translate it into normal English. Call a lawyer. I'm sure they'll be able to help you sort out what that means. And a lot of times those letters sound really scary, but it could be just something as simple as, hey, we couldn't read the specimen, can you please just send us another file? But they're worded strangely. And
Yep.
so you get this official-looking letter, and you just put it on the desk and don't want to look at it and assume it's bad news. And sometimes that's the case, and sometimes it's not. So that would be the advice I can give you in dealing with, or trying to do it yourself if you